And thank you for joining us, everybody, for today's Mackinac Center's Opportunity Michigan virtual event. Today, we're diving into the Freedom of Information Act, or FOIA, as it's commonly known. We're going to unravel how this tool can help keep our government transparent and accountable. And of course, we'll share some handy tips and tricks on making those FOIA requests really count. I want to introduce our speaker, Steve DeLee. Steve's not just any speaker. He is our go-to expert here at the Mackinac Center, wearing two big hats as the Director of Labor and the Director of Transparency and Open Government. Steve is a graduate of Hillsdale College. His journey before joining Mackinac in 2020 is nothing short of impressive. From working with a former Chief Justice of the Michigan Supreme Court to the Federal Reserve Bank of Richmond, not to mention his private practice expertise in employment and labor law, municipal law, contract law, and yes, of course, the Freedom of Information Act. Now, before we get to Steve, I want to play a video that shows you more about what Opportunity Michigan is all about.
Have you ever wanted to make a change? But have you ever been frustrated when you've tried to make a change, but nothing happens? Like when you vote. Well, that's because change doesn't begin in Lansing or Washington, it ends there. To inspire that change, we've created Opportunity Michigan. Opportunity Michigan is a network of people from all walks of life, and the Mackinac Center will equip the network with the tools and resources you need to make the change we all want.
Change begins with the people of Michigan working together for a more free and prosperous state. That's why I joined Opportunity Michigan.
You can start the change with one action, causing a ripple effect that cannot be ignored. That's why I joined Opportunity Michigan.
I want to be part of an interconnected network for change. That's why I joined Opportunity Michigan.
It's a place where we can share information, connect with each other, and make our voices heard. That's why I joined Opportunity Michigan.
Our community can inspire positive change by uniting behind one common goal. That's creating a brighter future for our state. That's why I joined Opportunity Michigan.
Good afternoon, everyone. My name is Steve DeLee, and I'm the Director of Transparency and Open Government here with the Mackinac Center. I'm very excited to come to you during this Sunshine Week here in Michigan to talk about our transparency laws here in Michigan, especially those with the Freedom of Information Act. So as we move to the next slide here, what I've got for you are the two fundamental transparency laws here in Michigan. The first is what we're focusing on today, which is the Michigan Freedom of Information Act. The second is the Michigan Open Meetings Act. I'm not going to talk about that one today, but suffice to say that requires public bodies to make public decisions in public meetings. And there's some exceptions on that, but we'll focus on that at a later date. So as we move forward, I want to really talk about the structure of FOIA, because FOIA is actually a really well-structured law. It starts with its purpose, and the public purpose of FOIA is a very laudable one. It is to allow people to gain access to the information that they need to be able to hold government accountable. Essentially, FOIA allows you to search for public records. They're your records, and they allow you to use that information to be better informed about how you want to participate in the democratic process. And that's how FOIA opens. That's its first section. Following that, FOIA provides some standard definitions. These definitions are very important. How they are phrased can make a very big difference in how your request is processed, or maybe even how a lawsuit turns out. But those definitions are fairly self-explanatory as you read through them. They cover what is a public records request, what is a writing, what is a public body. Those are the kinds of things that FOIA defines very early on, so that throughout the rest of the statute, it's very easy to understand. Next is a walkthrough of how you can actually request information. You have a right, as long as you're not incarcerated, to use FOIA to seek information. And you can look for information going backwards. This is records that already exist that you want to know, hey, how was this decision reached at the, let's say, Department of Health and Human Services? How did you come up with this policy? You can go back and get the email correspondence, any studies that they may have had, those sorts of records that have already been created. You can also request records going forward in the future. And so under Section 3 of FOIA, you can actually request a subscription for any record that's regularly created within the next 6-month period. So if you're a local watchdog, for instance, and you want to know what city council packets are like for the next 6 months, you can ask for those in advance. You'll have to pay for them just like any other FOIA request, but you can get a subscription to that so you don't have to request after the fact, week after week or month after month. The next section of FOIA really talks about the fees, and this is going to be a focus of some of the things that we discussed today. FOIA is very much designed to be affordable for average citizens. It's supposed to be fast, and the fees are supposed to be reasonable. Those of us with experience in FOIA know that that's not always the case, unfortunately. And I'm going to share today some tips and tricks with you on how you can phrase your FOIA request to kind of cut down on those applicable fees and really make it more likely that you're going to get what you're looking for. Next stage is the process of FOIA. This is how many days does it take a public body to respond? How many days do I have to wait before I can send a follow-up? How long does a public body have to actually process my request? What do I want to do if I think that they took away too much of my request through redactions and I want to challenge that or the underlying fee? And that's the next stage of the process is the appeals, and it's fees, withholdings, and redactions. Those are the things that you can actually challenge. A fee challenge is essentially, hey, look, the public body has told me it's going to cost this amount of money to process my request. I think that's too high and not consistent with FOIA. And so you can appeal that fee. You can also appeal redactions. So those of you who have done FOIA requests may have gotten back records that have black bars or that are entirely blacked out with no ability to really tell what that information is. Well, if you have, you can challenge that. It's not always the easiest thing in the world, but again, we'll share some ways that you can do that. Next section of FOIA is what happens if you win. What happens if the public body, in fact, wasn't correct in redactions or in their fees? Well, there are some fines and penalties for them associated with that, and you can get attorney's fees. It's not always the easiest thing in the world to get from a court, but FOIA does allow for that, and that's designed to make sure that ordinary citizens who are challenging these kinds of determinations still have a meaningful chance at getting the information, even if they couldn't otherwise afford to sue. One of the most important sections of FOIA, and one that we're going to spend quite a bit of time talking about today, is Section 13, and that governs all of the exemptions of FOIA. These are categories of information that we've determined through our legislative representatives are information that we shouldn't disclose to other members of the public through a FOIA request. So it's the exact things you would think of. It's Social Security numbers, it's private information, medical information, attorney-client, those sorts of things. In theory, these exemptions have a noble purpose, but in practice, they can be sources of concealed information that we really need to carefully look at and make sure that they're being applied properly. Final thing we're talking about here with FOIA today are the redactions themselves. When you look at those redactions, how do you kind of tell what they are? How do you tell whether they're appropriate? What can you do about it when those redactions are too broad in terms of what you're looking for? So as we move on to the next slide here, where I want to start with you is just the FOIA process, right? What is a FOIA request? Many of you may think that a FOIA request is simply under the Michigan Freedom of Information Act, I hereby request this record, and this record. And that certainly is a FOIA request, but there are far more ways to actually issue a FOIA request. Under the definitions, technically, any written request for information to a public body is a FOIA request. And some of you may have run into this before, where you ask a simple question, hey, what happened at last night's township board meeting? And you get a response that says you have to submit a FOIA. Well, technically you have by asking that question. Generally speaking, if you just want a simple answer to your question, you want to ask that simple question without referencing FOIA. FOIA puts you into a fixed legal process with timelines and restrictions. And so if you're looking for a quick answer, the best thing you can do is just ask the simple question without mentioning FOIA. But sometimes they force you to make a formal FOIA request. And sometimes it's just what you want to make sure that you have the legal backing behind you and make sure that there is a defined process so that they can't ignore your question. Which brings us to, how do you make a FOIA request? Well, the easiest way, and by far the most common way nowadays, is to simply submit an email to a public body's FOIA coordinator. And if you're talking with state public bodies, they almost all have FOIA coordinator information on their website easily accessible, and most of the time you can just click it. It takes you to your email tab and you can ask for your FOIA request. For those of you who are dealing with FOIA on a more local level, that's not always the case. A simple phone call can typically get you the information you need, but the default rule is that for your townships, your cities, your counties, it's the clerk is who's going to serve as the FOIA coordinator. And so if you can't find the FOIA coordinator's information and you can't get an answer to who the coordinator is, the default is going to be the clerk of the public body. So once you've made your request, how must the public body respond? Well, the public body has 5 business days under the law to respond to your request. By the way, if you make your request via email, it doesn't count as having been received until the next business day. But from that receipt date, the public body has 5 business days to respond. And they can respond in a number of ways. They can grant your request in full, meaning they're going to give you everything you asked for with no redactions whatsoever. That's pretty rare because even run-of-the-mill requests typically have some information exempted. The other thing they can do is say, no, we're not giving you any of the material that you asked for. This is a little bit more rare, and it usually only comes up in very specific context. A great example, and one that happens fairly frequently, is a public body mentions that they have a legal opinion and that they want to act in accordance with that legal opinion. Typically, this results in a citizen saying, well, what did the legal opinion conclude? Which is an excellent and perfectly valid question. But that information is attorney-client privileged. And so those kinds of requests are going to be frequently denied in full. Outside of that limited context, that's not very common to see. What is very common to see is what's called a partial grant and a partial denial. This happens 90% plus of the time. And this is when a public body agrees to give you some of the information you're seeking, but not all of it, and they apply redactions. Those are the 3 overarching options for FOIA as a response. But during that first 5 days, the public body can say, your request is sufficiently burdensome that we need an extra 10 business days to respond. In theory, that's supposed to only apply to large requests, complex requests. It's not supposed to be a default position. In practice, it's exceptionally rare to not get a 10-day business 10 business day extension. There's not really a mechanism to stop public bodies from taking that extension. There's not really a way to challenge that determination that's really effective. And so the default position seems to be, don't expect any kind of answer for the first 15 business days. Once those days are up, they will have to respond with either the grant, the partial denial, or the denial. What they will typically do is say, your request is granted in part and denied in part. And here's how much money we think it's going to cost us to process it. Here's how long we estimate it'll take us to process it. And we require half of that money up front. A couple of things on that. Most importantly, the time estimate that they give you. Let's say you make a request and they say, hey, we believe this is going to take 2 months. That is a non-binding cost or time estimate. They can't be held to that with strict accuracy. They do have to work what's called reasonably diligently to fulfill the request, but that's not a fixed timeline. So if they say 2 months and they're 2.5 months in, it's almost impossible to challenge that. Now, if they say 2 months and you're 9 months in, then you can probably make a case that that was an inappropriate estimate. But for the most part, the public body sets the timeline. Once they have all of the records, they will contact you for the remaining half of the deposit that is due, and then they will produce the records. Most of the time, you don't get to see them in advance. Some public bodies will, but for the most part, no records until you have paid. And then they get to produce the records themselves. And this is where you typically see for the first time what kind of information they are going to produce. Is it redacted heavily? Is it actually responsive to your request? Or was one of your keywords so broad that you're getting a whole bunch of advertisements, let's say? And then beyond that, how do you challenge that, right? If you think there's a lot of redactions here, what can you do about it? So as we move past the process and we move into the exemptions on this next slide, what we'll see is this is the section that you see on your screen right now. That's the citation to the exemption section of FOIA. And currently, there are 26 exemptions in FOIA that apply to public bodies right now. It's technically more because Michigan is one of 2 states in the nation where both the governor's office and the legislature is immune from FOIA. They are not subject to it. There's actually currently a bill package that just passed through the Senate committee this morning that would fix that issue. But right now, that's not the case. So of these 26 exemptions, these are going to apply from everything from your local school districts and townships and cities, all the way up to MDHS, MEDC, any of the big acronym agencies that our state is well known for. And these exemptions can be applied by any of them. And they're sensible exemptions when you really look at them. And I've thrown up a few on the screen now, and I'll kind of explain. I think we would all agree that the government shouldn't be sharing other citizens' private information through FOIA responses. We want to protect our privacy. We want to protect the privacy of other citizens. And so that's a reasonable exemption. You've got to balance it, and the exemption does. How the exemption balances that issue is it says there may be some pseudo-private information that is of a great public interest. And so if you're going to withhold something on privacy, the privacy interest has to clearly outweigh the public's interest in learning what the information is. That means if you have a really strong privacy interest, let's say you're discussing something intensely personal in a correspondence with a public body, or it's something that would be very intimate or embarrassing or confidential, that will be protected. But if you're talking about a major policy decision that involves some privacy information but affects, let's say, the health of a city or a state, that information is going to be disclosed because the privacy exemption, the privacy interests there don't clearly outweigh the public interest in knowing what that information is. Next exemption I'd like to talk about is the frank communications exemption. This is an exemption that is designed to allow public officials to speak freely with one another. And the logic behind this is essentially policymakers need to be able to speak plainly about what they think about a policy. If I think that the one-way street should go one direction and my colleague thinks that it should go the other direction, we should be able to tell each other why without a great deal of fear that if we speak too candidly, we're going to find our names in the newspaper the next morning. The problem with this is how it's applied. So the privacy exemption I mentioned earlier, the courts have been very good about applying. Public bodies have been a little bit more spotty, but the courts have been very good. On frank communications, that's not necessarily the case. The way that frank communications is supposed to be balanced is that you look at the public's interest in allowing people to speak freely with one another at a policymaking level, with the public's interest in learning what they were saying. And the default is you're supposed to be able to find out what they were saying so that you can figure out how policies were being formed. A great example of this is COVID policy, right? Sure, those officials there was a public interest in letting those officials speak plainly with one another when coming up with whatever solutions they were going to come up with. But COVID policy and COVID itself was such a huge matter of public importance that none of those communications should be exempt from disclosure, because we as the public need to know what was said and how that decision came about in order to really understand what was going on with that policy decision. Last example I'll give here, and like I said, there's 26 and we don't really have enough time to go through all of them today, is the security exemption. So there are exemptions in FOIA for information that would compromise physical security or cybersecurity. And that makes sense. We don't want to give the hacking community any extra tools to infiltrate our public infrastructure. We don't want to allow security plans for prisons or other facilities to be freely disclosed and published, simply to keep the public safe. I will say that the application of this, however, has been questionable. I've seen security interest applied to things as simple as email addresses or the names of a working group dedicated to a particular policy issue. These kinds of applications are where we really have issues with the exemptions. So the exemptions themselves are not the problem, it's how they're applied, generally speaking. Regardless, if an exemption is going to be applied, the public body has a duty to separate the exempt information from the non-exempt information. That means you shouldn't get an entire sentence that's blacked out unless all of it is exempt. If a certain portion of it is exempt, say a person's name or blood type or something like that, then all of the rest of the sentence should come in, with the exception of that limited information. Practically, that's not always the case, and I'll give an example. We recently FOIA'd Michigan State University for information relating to a mega site. It had been reported in the news that Michigan State was attempting to sell land that the news said they may not be able to sell due to some legal restrictions relating to the gift of that land to MSU. We asked for the gift agreement. We wanted to see, is that true or not? Was there a restriction? And what we got back as part of that agreement was a page, 8.5 by 11 white sheet of paper, that was nothing but black ink. And I'm not being hyperbolic when I say that. The entire page was blacked out. Well, that's not how the exemption is designed to apply. You have to provide some of the non-exempt information. Well, you have to provide all of the non-exempt information. We challenged that and were eventually able to settle that case and get the information we were seeking in there. But that's an example of where the duty to separate wasn't followed. And that can be challenged either through an administrative appeal or through a lawsuit. Final point I will leave you here with on exemptions is that they need to be applied properly. And when they're not applied properly, you can challenge them. The unfortunate truth is that the default position right now here in Michigan is that they aren't applied properly. So if you think that the exemptions that you get back in response to a FOIA request aren't particularly strong, you are probably right about that. So let's go ahead and move on here to just a general discussion of FOIA in theory versus practice. And we've kind of discussed this already. In theory, FOIA is supposed to be fast, it's supposed to be cheap, it's supposed to be transparent. It's supposed to work for ordinary citizens and work for journalists and work for everyone in such a way that if I want to learn information that the government has in its records, I should be able to get that in a matter of days for a relatively accessible cost and use that information as I see fit. Sometimes this is a journalist printing a news story based on records that they found and what they reveal. Sometimes it's learning what public officials are communicating to each other via email or text message. And sometimes it's just, hey, I'm learning more about the history of my own personal property or something like that. There's not really a limit on this in terms of purpose. In practice, this isn't the case. In practice, what we have with FOIA are really three major problems. There are excessive fees, excessive delays, and excessive redactions. Excessive fees come in when the public body is charging fees under Section 4 of FOIA. But the issue that you have with that is it's very difficult to challenge. And if you have multiple entities or multiple people reviewing your request, if they use the wrong hourly rate, if they're charging more than they should under the statute, your bill can be thousands of dollars just to get started on your FOIA request. Well, most of us can't afford to pay thousands of dollars for public records. So those requests get abandoned, and that leaves a whole bunch of very interesting information off the table because people simply can't afford to pay for it. The excessive delays also poses a problem, and this is most common when I speak with reporters and journalists, is some stories like the Flint water crisis, the information relating to that is going to be evergreen. It's going to be the kind of information that people are going to want to read about for years and years in the future. But not all news stories are that way. Sometimes you end up in a scenario where the information that you need this week, because if you don't publish the story next week, the public's not going to be interested and it's going to cause problems. Well, with what is essentially a mandatory 15 business day waiting period at minimum, a lot of those kinds of requests fall to the wayside because the information isn't as valuable anymore. The final problem, and this is what we were just discussing, are excessive redactions. When you get way too many redactions, one, it can be difficult to tell whether or not they're properly applied. If the entire sentence has been eliminated, how do you really know what that sentence might have said? Another similar problem is that most public bodies, when they're applying redactions, don't tell you, hey, this sentence is being redacted due to privacy. This sentence is being redacted due to frank communications. What they'll do is they'll just list all of the redactions in a cover letter, and then you get the blacked out pages. So you don't know what applies to what. And this can make that very difficult to challenge, and it's expensive to challenge. There's a couple of ways you can appeal, but essentially one of which is going to court. Well, it's very expensive to hire a lawyer. It wouldn't be at all unreasonable for a lawyer to ask for a $10,000 retainer in order to begin a FOIA lawsuit and to begin that case, in private practice at least. And that is prohibitively expensive for many people, even if you might be able to get attorney's fees if you win, because you don't know that you're going to win and you don't know that those are going to be awarded. So each of these three prongs really makes it much harder for citizens to use FOIA effectively. And that's a real practical issue. and one that we hope to be able to solve or at least avoid through some best practices here. So we do have a model FOIA request, which we're going to turn to in just one moment. And this is a model request that I've drafted. I drafted this and it's posted on our website. It's available to everyone. I encourage you to take a look at it. And there's two forms of it. We're going to take a look at it in just a moment here. But the one form is a clean copy. Just make it easy to read and copy and look at. The second is an annotated form. This is a form where I've left footnotes to explain why each section of this request is important. And I'll do a little bit of that explanation here today, but I would really encourage you to take a look at that more thorough explanation after the webinar today. The general tips I wish to leave you with are think outside the legal requirements of FOIA. What you want to do is you want to communicate and clarify your request with the FOIA coordinator as much as possible. Some of what we are going to do today is give you ideas on how you can make your requests less burdensome, less expensive, and faster just in how you write it. But really the best way to make FOIA work for you is to work with the FOIA coordinator, communicate with them, see if they're willing to give you a call, and try and talk about, hey, what are you really looking for? How can we get there? And I have a great example of this that happened to me just earlier this year. I was searching for some information from the Michigan Department of Agriculture and Rural Development. And I don't typically FOIA MDARD, but it happens every once in a while. And I sent a request that I didn't really have a super clear idea of what I was looking for. So I did my best using the tips that we're about to go through, and I sent the FOIA request off. And a few hours later, somebody from that office gave me a call and said, hey, I see your request. Let's talk about it. I have something here on my desk that I think probably gets you 85% of the way to what you are looking for. If you want the other 25 or 15%, and you are entitled to have that, I'm going to have to clarify it with you a little bit, and then we'll send it to the other departments. Fair enough. That's a great response from a FOIA coordinator. That is what you want. And so I took a look at the information that she offered me. It did everything I wanted. It made the other remainder of my request completely unnecessary. And I called her back and I canceled the FOIA request. So instead of waiting at least 15 business days to get the information I sought, because I had a good FOIA coordinator, they reached out to me, saved themselves having to go through this process and risking some legal liability if something was wrong, and saved me all of the time and money associated with waiting for that request. That's the kind of relationship you want to build with a FOIA coordinator if you can. You can't always do that depending on circumstances. So if you can't, what we need to talk about now is reducing the scope of your request to the most narrow, most focused level possible. And so the way that we're going to do that is we're going to go through my model request on the next slide, and I'm going to walk you through some of the key elements of that. So really, the model request has a couple of key features to it. The most important features are notated with the footnotes themselves. But as you go through that, what you'll see is a couple of key elements. So let's start with the first sentence of that model request. If you look at that first sentence, it says, pursuant to the Freedom of Information Act, gives the citation, I hereby request. That isn't just putting the FOIA coordinator in the mindset of, hey, I need to be thinking about this as a FOIA request. It does that, and that's extremely valuable. But that's not all it does. What it also does is it triggers a provision of FOIA that very specifically will add appellate fees and fines if they don't process it in the correct way. So that is actually a provision designed to add legal liability, and that's a very, very helpful thing to have in your request. Don't do this in your emails if all you're asking is the quick question. Remember I said earlier that the quick questions can sometimes work better than the actual formal request. Don't put this language in there if you want to go the quick question route. But if you want to be in FOIA, start off with this language. Next portion there, as you move beyond that sentence, what you'll be able to see is describe the records. And if you take nothing else away from this today, this is absolutely key. All the time, I see FOIA requests that say, I request any and all records. So let's use Flint again as an example. I request any and all records relating to the Flint water crisis. You're going to get back a cost estimate that tells you this is going to cost you $75,000, and it's going to take us 3 years to process. Probably even more in this case, but that's a random number. The problem that has occurred is FOIA coordinators don't look at that request in the same way that a requester does. If I were a FOIA coordinator, and I have served as one in the past, you look at that request and say, you want all of the communication, all of the emails, phone records, text message of everyone in my public body that relate at all to the Flint water crisis, regardless of whether it contains the word Flint or not. It may describe it vaguely. So now I have to go through the entire public body's communications ever since that became an issue. So we're talking going back years now, and reviewing them all manually to determine what's responsive before I even start redactions. You want to avoid that. What you want is to be very specific in a couple of ways. If you can narrow down the time range for the records that you're looking for, please do. If you can say, okay, perfect example of this. Last week, Gongwer, which is a news service out of Lansing, asked for text, or I believe it was emails and text between between a few people that are high-ranking in the Attorney General's office. Essentially, there's a debate going on. When the Flint water crisis started, Governor Snyder started a criminal investigation. During that investigation, Attorney General Nessel and Governor Whitmer were elected. And the Snyder administration provided the new administration with its investigative reporting and essentially its conclusions up until that point. Attorney General Nessel's office decided to restart that investigation. And there's some debate in public over whether that was a good idea or whether that was a mistake. We know now that the only criminal convictions in Flint are not convictions, they're pleas, and that the remaining charges were dismissed. The Attorney General's office is no longer pursuing that, and there's been a civil judgment. So Gongwer wanted to see the communications relating to that, and they were told that they couldn't due to the frank communications exemption and some other things. Well, if I wanted to see something like, hey, how is the Attorney General's office responding to the news story talking about this difficulty they were having, how would I do that? Well, first thing I do is narrow it in time. I know that this happened over the last 2-3 weeks. So I'd say I want all records created between date X and date Y, that 3-week period, so that they're not searching for the entire year or even further back. Then I would specify the precise people's records that I'm related or that I'm interested in. So if I may want Attorney General Nessel's communications and maybe some of her chief deputies, or maybe I want to go broader because I don't know who's talking about this. How do you do that? Well, the easiest way is to use email domains. So I may not know who is talking about this, but I could say any email between Attorney General Nessel's office or Attorney General Nessel herself and anyone with an @michigan.gov email address. That still narrows things down quite a bit, especially if I say I only want the emails sent or received by the Attorney General herself. So we've narrowed it down by time frame. We've narrowed it down by sender and recipient. What else can you do? Keywords can be very helpful, especially if you're dealing with a public body that can do search functions. So input the words that you're looking for in your request. An example, I want all records dating from January 1st to January 31st, 2024, from Party A to Party B that contain the words water or Flint or FOIA or any of that, or any other keywords that you think are helpful. Think carefully about those keywords. You don't want them to be things that are very, very, very broad because you'll pull in a lot of records that you are not interested in. The other thing to think about is, just like all of us, public officials get on a lot of mailing lists. And so try to avoid words that may appear very commonly in advertising, in media hits, for an example. That'll really help narrow down what you have in terms of records that technically respond to your request, but that you aren't interested in. As you move past how you describe the records, the next sentence is also very important. And this is a portion of FOIA that allows you to stipulate to the electronic record, or that records be produced to you electronically. If you want records in paper, you can ask for paper records. It's typically more expensive. But FOIA actually allows you to require a public body to give you electronic copies unless they are technologically incapable of doing it. Nowadays, that's not very common. So I add this sentence into my FOIA request specifically to make sure that I'm getting electronic copies in PDF format. Now, the next portion here of FOIA is optional, but I like to include all of this in my request because it kind of gives you an air of credibility. And this is just a citation to a lot of legal language that helps show that you know what you're talking about, first of all, but it also helps educate FOIA coordinators. If you're dealing with a large state public body, their FOIA coordinator knows what their job is. But a lot of smaller municipalities may not. I've personally worked with municipalities who might get 2 FOIA requests in a decade. You can't expect somebody who doesn't process FOIA as frequently to really be as familiar with what they have to do, separating exempt from non-exempt material, telling you if they're withholding a particular record, making sure that they understand they have an obligation to tell you which redactions or which exemptions apply to their redactions. And so this paragraph that you're looking at there really walks you through those obligations and helps educate the FOIA coordinator. Beyond that, this is what I consider to be one of the most important things you can add to any FOIA request. Even if you don't include my legal language, that's totally fine. The one thing that's key in handling this is the sentence where it's essentially asking, it's begging a FOIA coordinator to contact you. It's, hey, if there's anything I can do to narrow my request, or if anything I can do to clarify it, please email or call me. You want to have that in there because you want to give good FOIA coordinators a hint, a clue that you're easy to work with. You're not trying to cause them more work or more difficulty. You want to make their job easier, and you're willing to talk through it to make sure that happens. I highly encourage this in all of your FOIA requests. And I have one last piece to discuss on this model request before we move on to the appeals section. And it's a minor piece, but it's important. If you look below the signature line, there is a portion dedicated to your address. You are required under FOIA to provide your physical address when making a FOIA request. This comes out of an issue that came up years ago relating to an anonymous request for ballot information that caused pandemonium among FOIA coordinators for about a month and a half. But this is just a measure designed to make sure that these kinds of more anonymous requests are actually backed by a human being. And you will have your FOIA request bounced back if you don't put your address in there. So be sure to do that. So that's kind of a walkthrough of the model request. As I mentioned earlier, please take a look at the full version on our website, and we'll tell you where to find that at the end. But for now, I'd like to discuss briefly the appeals section of FOIA. So we've moved on here to the next slide. And this appeal, and how do you do a FOIA appeal? There's 2 ways. It's an administrative appeal or a lawsuit. The administrative appeal is the easier route to go, and one that I would encourage anyone who isn't interested in a lawsuit to take. Admittedly, these are harder to win because the way these work is the public body tells you no, and you appeal to the public body telling it that it made a mistake. They can work for either fees or redactions, and I've seen them work, but it's not likely to be as successful. You should still do it to try and make this as transparent a process as possible, but it is an uphill battle. Now, a tip I have for you on that is, and we'll share this portion of our website too, is if you go to our litigation portion of our website and you check out our transparency cases, we actually post all of the lawsuits that we file and all of the documents in them. So you'll see complaints and motions and briefs. If you're going to do an administrative appeal, we've probably sued over it before. It's worth taking a look over some of those complaints and the language, highlighting what a public body has done and why we think it's wrong. There's plenty of examples on frank communications, on privacy, that you might be able to learn from and even use in your own administrative appeal. Of course, I encourage you to talk to your lawyer and your counsel, but these may be helpful tips and tricks if you're going to do an administrative appeal. A lawsuit is usually more effective, but they're slow. Average probably about 6 months unless somebody is willing to settle. They're expensive. Like I said, a $10,000 retainer is not unreasonable for this kind of a thing. But there are attorneys who handle it, and then we handle some cases. We certainly have represented ourselves in FOIA, but we also take on outside clients in pro bono transparency cases. That we can't promise that we take every case that comes through our door, and there are a lot of cases and only a few of us. But we do take those cases that have a real statewide interest and where we can hold actors accountable for some truly non-transparent behavior. Those are really your appellate options. That's the best path, is the administrative appeal. And after that, you've got to talk to an attorney. Like I said, check our website for some of those legal complaints. So we're about to finalize the discussion portion of today. Essentially, what I want to leave you with before we move into Q&A are some resources I think that you may find helpful. So we do a lot of FOIAs and we do a lot of standard FOIAs. A couple of those are featured on our Frank Beckman Center for Journalism. That is a program we have encouraging transparency in journalism here in Michigan. What you'll see there are employee salary databases. So if you've ever wanted to know what a public employee makes in Michigan, be it a state employee, school district employees, all that information we have already gathered for you, and it's searchable on our website. We also have a library of collective bargaining agreements for Michigan's local school districts. If you want to know, hey, what does the local teachers union contract require of our school district? That's available for you online, and it's also typically available on the district's website, but we have them all together for you. You can also find Michigan Capital Confidential, which is our media outlet. We cover stories that a lot of people don't, a lot of other outlets in Michigan don't cover. They're very interesting stories, they're very compelling stories, and we take a look at it from a free market perspective. Other resources available to you, as I mentioned, on our website, that model request exists. If you just go to our homepage and click on our transparency tab, you'll see a link to that, as well as a link to a number of our lawsuits that are currently active. And you'll also find what a study that I did last year, or earlier this year rather, on how you fix FOIA. And what I did is I sat down and rewrote the statute line by line based on my experience to try and make public bodies more accountable, to make FOIA cheaper, and to make information accessible to the people faster. That study is available online. As I said, it's called Fixing FOIA. That's also on our transparency tab. Finally, before we move into Q&A, what I just want to share is thank you for being a member of Opportunity Michigan. I'm very happy to have all of you here. If you think this kind of information was valuable, please let us know. And above all, please share this with other like-minded people that you think would benefit from these kinds of presentations. With that, we're going to take a brief intermission here to move into Q&A, and I'm excited to answer your questions.
And hello, everyone. I'm back here now. Thanks, Steve. A lot of great information. I've been learning so much as well. You know, I used to be a journalist in my other world, my other profession, and it's just so useful, all of this information. We are getting questions. Any of you watching right now, go ahead and write your questions in the chat, and Steve will try to answer them. We already have one coming in from our viewer out here, and I'm going to read it for you. It says, please discuss the requesting of documents around COVID. For example, I'm concerned that our county medical officer mandated school masking and closures. Can you provide an example of requesting around that decision making? And I know that's something as well that we were involved in on several levels.
Yeah, absolutely. So COVID and FOIA was a very difficult topic for all of us. We went at it from a Michigan Department of Health and Human Services perspective, and we also FOIA'd University of Michigan. If you're looking for the decision-making, what I would say is don't ask for correspondence in this case. It's too long of a process. There was too much going on. Unless you know that the county health officer was talking with one or two specific people, I would focus on what kind of science and data did you have? Who were you working with? What reports were you receiving? Ask for those. And I recognize that this is going to be a scenario where you may not know what records exist. So set it for a brief period. Set it for a month where you think that something important happened. Limit it to the top official and throw in a couple of keywords that aren't COVID that would capture that kind of reporting, study, data, that sort of thing, and try to get at it that way. And then from there, expand out. So once you get some information, it will probably lead you to other directions that you can use to ask for more information in later requests.
So the more specific, the better. If you know exact words, phrases, the more specific you can be.
Exactly. One of the biggest mistakes with FOIA is everybody wants to go very, very broad because you don't want to miss anything. And that's a perfectly reasonable position to take. But that's where you get these extreme prices and it's impossible to get your records. So what you want to do is counterintuitively be as narrow as possible, see what you get, see if it points you in a direction, and chase that direction. And if you don't get anything that allows you to follow up, then you can expand out slowly until you get that information.
Okay, got another great question here. Thank you very much. Someone writes, the municipality I live in has not had a budget since 2021. Interesting. Is a FOIA an appropriate option for actual expenditures?
Absolutely. So one of the very common FOIAs that happens all the time at the municipal level especially is if there's a lawsuit, the lawyer's bills get FOIA'd. You can FOIA for the expense reports, you can FOIA for any of the actual outgoing bank statements. You can ask for any of that material. Again, narrow time window to start. But yeah, absolutely, all of that's accessible under FOIA.
Okay, and the questions keep coming in. Keep giving us the questions. Steve's here for a little longer. Someone else writes, I'm concerned about a contract my county gave to an LLC to rent their warehouse for a very high amount to store PPE equipment. How can I request in a way to find out how the vendor was selected? Is that a tough one?
It can be. Vendor selection is tricky because technically speaking, it's supposed to happen in the open. It should happen at an open meeting. But that doesn't tell you all of the information that went into that decision. It just tells you the decision was made. What you want to look for are RFPs, requests for production. You can ask for that specific project, again, in that specific time range. You can ask for correspondence with the township from the winning vendor, but really where you get at this is going to be the RFPs and the request for bids, essentially, and then correspondence relating to those RFPs. That will tell you if somebody was saying, and I'm not saying this is the case, but as an example, hey, this is my cousin's business, I really want to support it. We should award this vendor contract to him or her.
Okay. One more here. With regards to a subscription FOIA, how soon after the document is created does the document need to be produced by the requestor?
That's a really tricky one.
Yeah.
There is no real answer to that. So part of that is because the record is created on a regular basis. Otherwise, you can't get a subscription for it. So in theory, how this should work is if I want to get the city council board packets, for example, and those are created 2 days before every meeting. The ideal scenario and what's envisioned by default in FOIA is that when those packets are sent to city council, they just get sent to anybody with a subscription at the same time. But there's nothing in FOIA that requires that. So subscriptions are an area where FOIA isn't really well fleshed out. And the example for that is cost. When we talk FOIA, there are strict costs if you're asking for past records. But for a subscription, you're asking for records that don't exist yet. So you can't precisely calculate how much it's going to cost the city to process. Well, in that case, they can charge you more than they can charge you if you do after the fact request because they don't know. And some municipalities have used that extreme to charge a lot more for a subscription than anybody is willing to pay.
Oh, interesting. They keep coming in here and we still have time, I believe. Wow. Thank you everyone, by the way, for being here. Your opinion on the 30-day waiting period in SB 670 passed, they say here by the Senate committee today, and that was passed today. I'm not sure. I wasn't in the loop today yet, but the 30-day waiting period.
Yeah, so if you want, you can check my testimony. This is on our website. I've testified on SB 669 and 670 before. For those of you who don't know, this is the bipartisan bill package that, among other things, opens the governor and legislature to FOIA. This is, in particular, is a question that references one of a large number of new exemptions that apply to those branches and those branches alone. And one is essentially for transitory records. If the record is created and deleted within 30 days, it's deemed essentially not important enough to be FOIA-able. I have significant concerns about that, and I've shared my concerns with the Senate committee and the sponsors, because that kind of encourages an environment where you may want to set a 30-day retention for everything and just essentially have that exemption swallow the whole. It certainly encourages rapid deletion of anything that might be incriminatory. And so I'm not in favor of that exemption. I still think that opening the governor and legislature up to FOIA is important. And so that's a key element of those bills. But I have concerns with a number of the exemptions there, and I've expressed those.
Okay, another question here. Thank you very much. Can FOIA coordinators be shared by municipalities? Should the sheriff be responding, or can he have the county commissioner's coordinator respond for the sheriff's department? So can they share, especially municipalities, you know, they're cutting down budgets and so forth?
Yeah, so there's no real legal requirement that I can point to here. I mean, essentially a FOIA coordinator has to be designated by township, city, et cetera, clerk, usually, or by the head of the state agency. And there's no real rule about whether you can share. So I've worked for townships where the police has their own FOIA coordinator and the township has its FOIA coordinator. But But I've also had, nope, the township clerk does all of it for the police and everybody else. And there's no rule against that. I don't even know that it would be improper. Let's say, you wanted to start a FOIA coordinator business. I'm not even sure it's inappropriate. I don't think it would be inappropriate if you wanted to say, municipalities, I will process all your FOIAs for you. Yeah.
One more question. I'm not doing that though. How do I find out who is on the voter rolls that won't be cleared until 2025? FOIA when it comes to voter rolls in elections, is that more difficult or dealing with private information?
Yeah, that's very tricky. So there may be procedures under some of the laws that govern the Secretary of State that have specific rules. So like the DMV, for example, has different rules. The court system isn't subject to FOIA. We don't want them to be. Their system is better. But they aren't subject to FOIA. They have different process. So I don't know for sure whether the Secretary of State and the election stuff has that. If not, you can certainly FOIA for it. But you're probably going to have a lot of privacy exemptions in there. And so it's going to be very difficult to get that information unless there's another statute that entitles you to it. And I just don't know that off the top of my head.
Okay, we have a couple minutes left. Any more questions? We still have a little bit of time. You can ask. I want to ask, and it was asked in here as well. And I know you know the answer because you just rewrote the whole FOIA law, and you go to Mackinac.org, type in FOIA or Freedom of Information. What would you do to fix it? And you have worked on this so long.
Yes, I've worked on this for a long time. This project has been one I've been wanting to do for years and finally was able to do. There's a couple of key elements. So it's too nuanced to go into every particular detail, but there's essentially a couple of things you have to do. One is create incentives for public bodies to take FOIA seriously. Right now, the fines in FOIA are small enough that public bodies can essentially write off the cost of being sued for failing to follow FOIA as a cost of doing business. We have major universities here in Michigan, major research universities here in Michigan, who at one point had 3.5 FOIA coordinators for almost 50,000 people. Well, that's not going to be very efficient at processing FOIA. And that's not at all uncommon. We have state departments sometimes without any FTEs, full-time equivalent employees, who handle FOIA as their only job. Well, part of that is the fines are small. So you've got to increase the size of those fines for violations, especially when they're blatant. But at the same time, you don't want to punish small government. So you've got to adjust those fines based on whether you're dealing with, let's say, a University of Michigan versus a small northern rural township. So that's one thing you have to do. The other, you've really got to fix the exemptions in FOIA. As written, if applied in the right spirit, they're not a problem, but they're not being applied in that spirit. So you've really got to rework some of the language there to make clear, no, you can't read it this way. You have to apply it this way. The other thing, there's two other things that I'll hit on. One is when you're talking about exemptions, right now, almost all of them are permissive, meaning they're optional. Social Security numbers aren't, right? If you disclose that, that's a big deal.
Yeah.
But things like privacy, frank communications, all the ones that we talked about today, those are optional. You don't have to take those exemptions as a FOIA coordinator. And yet they still charge you to go through and redact everything under those. Well, under my system, they can't charge for those permissive exemptions. You can only charge if you're required to take that exemption by law. Okay. So that cuts down on your cost side. The other thing that it does is there's now a new default. If you've got 5 days to produce the records, you can take a 10-day extension, normal days, calendar days, not business days. At 15 days, you've got to give the records themselves, not just a cost estimate. And then if the public body wants to say, well, we can't do that, you've asked for far too much, that's fine. But they have to go to a third party, in this case, a court or a newly created kind of expert committee that handles FOIA in between the courts and the administrative appeals, and say, here's why I can't possibly do what they're asking me to do in 15 days. And then that third party is going to say, fair enough, but you only get blank number of days and you must deliver by this date. So there's no longer this vague estimate of what I think I might be able to do. They're stuck on a hard and fast date, after which you can immediately go to the courts.
And Mackinac.org, search your name, search FOIA, Freedom of Information, that'll come up. We got like a few minutes left and we have one question here, a few questions. I'm going to pick one. For a school board meeting, is it the expectation that public has access to the same meeting packets that the board members have? And if so, should those packets be free due to interest of the public?
Well, the second question is more of a policy question. So I would say yes to that, but not under a FOIA regime. The first part of that question is interesting. So should you be able to have access to the same packets that the board has? Yes, and you can through FOIA. They shouldn't be able to withhold much of that packet unless they're dealing with certain specific issues like employee terminations, discipline, and even then you've got to separate exempt from non-exempt information. Will you get those same packets at the meeting? As a practical matter, no. Sometimes the board packets are way larger than the agenda and the meeting minutes, and not everybody wants them. And so as a cost-saving measure, a lot of times those aren't going to be replicated. But if you ask for it after the fact, or you could try a subscription in advance, like I said, that's a little bit tricky, then absolutely, yeah, you should be able to get access to that.
Okay, one final question here, and we appreciate everyone, all of your questions. What is the most common type of FOIA request done by the Mackinac Center?
It's got to be one of the ones we do regularly. So our salary database, we FOIA every public body in Michigan, essentially, once a year. We ask schools for information once a year. So that's probably our most common one. Other than that, it's correspondence. Emails especially are a treasure trove because they tell you who's talking, they tell you about what, and even if you don't get attachments, you can usually see what they are, and that leads you to be able to FOIA for those later on down the road. So if you're talking one-off request, it's usually correspondence. If you're talking our regular requests, those are by far the most common.
And one last thing I want to add, FOIA requests, it's not just for a journalist or for you. It's meant for the public as well. And you touched upon this earlier, but if you're in the community, you have a nagging question and you really want to know, you have the right, correct, to file a FOIA.
Absolutely. And please consider us at the Mackinac Center as a resource. We're happy to answer questions on FOIA and to try and help you out as best we possibly can on this. So.
Okay, and everyone, Steve took months and months on your study, rewriting the whole FOIA law. You can go find that mackinac.org. Any closing thoughts real quick? Because I've learned so much since I've been working here, a former journalist myself, because it was really frustrating having to deal with FOIA.
Well, there's no question that FOIA can be frustrating, but when you get a well-written request and you get what you're looking for, it's amazing what you can find about the inner workings of government, and it's as interesting as it is useful. So give it a try. You don't lose anything filing a request. Keep the government on its toes, figure out what's going on behind the scenes. It's a lot of fun, and it's a very valuable tool.
That it is. Thank you very much. And once again, go to mackinac.org. Steve's going to take a look at these questions. If we didn't hit any of the questions, get back to you. You look them over, see if you can answer some of them.
Indeed.
But also our website is a treasure trove of information. Thank you for joining us, everybody.